This is the third and final part of the recorded lecture for Chapter 3. In this part, I will discuss the third form of law, legislation, and the concept of judicial review. Legislation is made through the democratic process. Sorry, I'm enlarging my screen here a second. Legislation is made through the democratic process. Whereas common law and constitutional law arise from the judicial process, legislation comes from the democratic process. It begins with a bill that is proposed by an elected representative, debated at length, revised through compromise and further debate until it is finally enacted as legislation and recorded in a code book. At the federal level, it is recorded in the U.S. Code, the United States Code, which I have pictured here. And then each state has its own state code of laws for state level legislation. And I've pictured here a few books of the South Carolina State Code. The U.S. Code and the state codes comprise a lot of books. I've only pictured a few here, but I don't want you to be under the impression that there's only one book containing all of the laws, because that is not the case. There are many, many, many different books that comprise the United States Code, and the same for state codes as well. A lot of laws, a lot of legislation. Legislation is a reflection of public policy. So whatever concerns the public would like the government to address will become the subject of legislation that elected representatives write. And it is often very detailed. That is because legislation is meant to regulate complex behavior. Think of our tax laws, for example. Tax laws are legislation that regulate economic activity of individuals and businesses. What about regulations for the processing and distribution of food? Well, that legislation governs the safety of what we eat, and it is very detailed. In fact, some legislation is so complicated that our elected representatives don't actually write it. Instead, they delegate the job of writing the legislation to an administrative agency. Administrative agencies are staffed by experts, scientists usually, who are trained in a specific area and are equipped to write the very detailed regulations needed to protect our environment, the safety of our food, the safety of our drugs, the safety of our roads, etc. So that work of the administrative agency is actually its own subset of legislation called administrative law. And we'll talk a little more about administrative law when we get to Chapter 7. But for now, just know that it is a subset of legislation that's made through the democratic process. Legislation can be amended or repealed through the same democratic process that created it. This happens all the time. A new president, a new Congress, they enter office and immediately begin repealing or changing legislation that reflected the public policy of their prior administration, and they write new legislation that serves the interests of their constituents. Legislation can also be invalidated through the judicial process. And this brings us to the matter of how legislation is connected to other forms of law. Remember, the Constitution is the document that created our federal government. The Constitution defines the power, the authority of our government to act. Our government is a limited government. Its power is limited to just what we authorize it to do through the Constitution. Article 1 of the Constitution defines the authority of Congress to enact legislation. It enumerates certain specific powers that Congress has, such as the power to levy taxes. It also authorizes Congress to regulate commerce. Congress can pass legislation that regulates economic activity, such as the processing and distribution of food and drugs, transportation across state lines, healthcare, etc. Article 1 also includes a catch-all phrase known as the Necessary and Proper Clause that enables Congress to enact whatever legislation is necessary or proper to carry out its enumerated powers. In addition to Article 1, several amendments to the Constitution have an enacting clause. The enacting clause will authorize Congress to pass legislation that enforces the amendment. For example, you see pictured here on the slide, or quoted here on the slide, Section 4 of the 14th Amendment. And we spent a good bit of time talking about the 14th Amendment and how it applies to states, how it was part of the Reconstruction Amendments, which were intended to place some controls on former Confederate states. They had to ratify the 14th Amendment in order to be readmitted to the Union. And the 14th Amendment gave Congress the power to carry out or enforce through legislation those provisions of the article that were guaranteeing equal rights for former slaves or for African Americans. Interestingly, this language in the 14th Amendment is what authorized the Civil Rights Act that I'm sure you probably learned about in other classes. So legislation is connected to constitutional law in the sense that the Constitution is what authorizes legislative power. Legislation is also connected to the common law in a way that I mentioned earlier. Common law was the first form of American law. Over time, certain precedents that were established through common law were later codified as legislation. And I say codified because the common law was written into a legislative bill and then enacted as legislation in a federal or state code. The easiest example of this codification of common law, and you'll see when we cover Chapter 5, the criminal law began as common law, but was later codified into a criminal code, a piece of legislation. The last section of this chapter covers the topic of judicial review. This essentially is an elaboration on a topic that we discussed a moment ago about the connection between legislation and constitutional law. Recall that constitutional cases involve disputes over the assertion of government power that infringes upon individual rights. So each of the constitutional cases we might read will be about some piece of legislation or even an act of the president that a private citizen is challenging. The issue will be whether the legislation is authorized by or violates the protections of the Constitution. Our courts, usually our Supreme Court, evaluates whether some act of Congress, some act of a state legislature, or the president even, whether it has violated the Constitution. And that is known as judicial review. It is one of the main checks and balances that controls the exercise of government power in our nation. So here we have the judicial branch checking the power of the legislative branch or the executive branch. Now let's take a step back for just a moment. We take for granted nowadays the power of the Supreme Court to evaluate the actions of other branches of government, executive and legislative. That seems commonplace now, but it wasn't originally. Where does the U.S. Supreme Court get the power to sit in judgment of Congress or the president? These are three co-equal branches of our federal government, equal branches. They have equal clout, as it were. And remember, our Constitution is the source of federal government power, and the U.S. Supreme Court is just a branch of the federal government. It's the judicial branch. So we have to start with the Constitution to see whether and how the U.S. Supreme Court has the power of judicial review. Article 3 of the Constitution organizes the judicial branch, and I have it quoted here. It vests the judicial power in the Supreme Court, but it does not give the court the specific power to evaluate or review the actions of a co-equal branch of government. That power of reviewing another branch's actions, whether legislative or executive, to determine whether those acts are constitutional, the power of judicial review, it exists because of one case that was decided in 1803. It was the case of Marbury versus Madison. It happened very early in the life of our nation. And rather than tell you all about what happened in that case, I want you to watch another short video that tells the story much better than I could. The link to the video is found in the agenda item for the week of March 20th through 26th, and you should watch it after you're finished with this lecture. I promise you it is not as long. It's only about 8 minutes, and it's rather entertaining, I think. I think you'll enjoy I think you will enjoy it, and I hope you will most definitely watch it, because otherwise you will have a difficult time understanding the importance of this case and the importance of judicial review. The case of Marbury versus Madison set the precedent for judicial review. It was the first time that the U.S. Supreme Court ever evaluated an exercise of power by another co-equal branch of government. From that point on, the U.S. Supreme Court could and did exert the power of judicial review. And the court didn't use that power very often, at least not until the 1900s. But the precedent was set, and now judicial review is deeply embedded in our nation's legal system. So how is judicial review exercised? That's the next topic. How do courts go about evaluating the validity of a piece of legislation? Well, they use tests or standards. They are called standards of review. These standards are a delicate balancing act in practice. The court is balancing the interest of government, which is supposed to serve the common good, with the interest of an individual. And there are many different standards or tests, and the one chosen by the court to apply will depend upon the individual right at stake. We're going to look at the three main tests, and I have them printed on the slide: strict scrutiny, intermediate scrutiny, and mere rationality or rational basis. These three tests operate on a continuum of sorts, with strict scrutiny at one end and rational basis at the other. The continuum reflects the level of difficulty for the government to prove that the legislation is authorized by the Constitution. The government's burden is nearly impossible to satisfy with the strict scrutiny test, but it is very easy for the government to establish that it has a rational basis for a piece of legislation. Intermediate scrutiny is a sort of middle-of-the-road burden, and sometimes the government wins and sometimes it doesn't. So here's what the tests are. Strict scrutiny means whether the government has a compelling interest that justifies the law, whether the law is necessary to achieve that interest, whether the law is narrowly tailored such that it does not infringe on an individual right any more than it must to be effective. And third, the government, I've listed all three. My point, though, at the end is the government bears the burden to establish each of those three elements: a compelling interest that is necessary to achieve. I'm saying this wrong. The government must show that it has a compelling interest to justify the law. It has to show that the law is necessary to achieve that interest, and it has to show the law is as narrow as it possibly can be. The government has to show all three of those elements, and it is incredibly difficult, if not impossible, to do. Then there is intermediate scrutiny, which is less than strict scrutiny, but not as easy as rational basis, somewhere in between. The terminology is whether the law is substantially related to an important government interest. So it's kind of fuzzy there, but just know that it's a little easier for the government to prove, to justify itself based upon intermediate scrutiny. Then the last test is rational basis or mere rationality. And there, the government just has to show a legitimate purpose. So does it have a reason? Is it rational? Or is it arbitrary? If it's arbitrary, it's invalidated. But if there's a rational reason, a rational purpose for what the government has done, then the government wins. It's almost a guaranteed win for the government. So those are the three tests here. And I don't expect you to memorize these tests. You would have to do that maybe in a constitutional law class, but I'm not going to require you to do that here. What I want you to do is pay attention to the ease or difficulty with which legislation can pass the test, and then when each test would apply. So as I said a moment ago, the choice of which test to use, it will depend upon the individual rights that are being infringed by the legislation. So some rights are deemed more fundamental to individual freedom than others are. And so legislation that infringes upon the exercise of those fundamental rights are suspect, and the government will have a very high burden to justify itself. These rights are actually called fundamental rights. And we'll talk more about fundamental rights and what they include in just a second. The other times when strict scrutiny is applied is when legislation infringes on the rights of a class or insular group of people. Some groups or classes are given special protection by our Constitution, and they're referred to as suspect classes. So let's begin by looking at equal protection and suspect classes. There's a clause in the 14th Amendment. Remember, the 14th Amendment applies to the states. That clause reads, "No state shall deny any person within its jurisdiction the equal protection of the laws." Okay, this underlined language is referred to as the Equal Protection Clause. It means that state governments have to treat all people equally. And that's a pretty simple statement of equality that is meant to be protected by our Constitution and a founding principle of our government. But it is a protection that was denied to a specific group of U.S. citizens for a very long time. And I'm speaking, of course, of African Americans. Race has been a mechanism of unequal treatment for a very long time. African Americans have been disenfranchised and denied access to the democratic process. And for that reason, constitutional law considers racial classifications suspect and applies the test of strict scrutiny to any law that treats the races differently. Women, as a group or class, have had a similar lack of access to the democratic process. Our history, our society is patriarchal. Men controlled the power of government and denied women their rights. So now constitutional law considers gender classifications as suspect, though less so than racial classifications. So it will apply the test of intermediate scrutiny to any law that treats genders differently. Then all other groups or classifications, age, for example, are not considered all that suspect. And so under constitutional law, the test of rational basis applies. There are rational reasons to treat age groups differently. So an example might be driver's license or alcohol or tobacco use. So there's a rational reason for a state to treat younger people differently, to deny them the right to purchase alcohol or drive a car. So that's why a rational basis test is what would be applied by the Supreme Court when evaluating those laws. And they're very easy to win for the government. So you can see that the constitutional law provides for different tests when the courts review laws that treat classes or groups of citizens differently. Some classifications are more suspect than others because the citizens who make up that class have not had a voice in the democratic process that yielded the law. They didn't have a voice in the process by which the legislation was originally enacted, so the judicial process protects them by applying the test of strict scrutiny. The next time constitutional law uses the strict scrutiny test is when fundamental rights are at stake. Fundamental rights are rights that are essential to liberty, what it means to live in a free society. The concept of fundamental rights is embedded in the Due Process Clause of the 5th and 14th Amendment. When fundamental rights are infringed by a piece of legislation, courts will apply strict scrutiny and the legislation will inevitably fail. So the main area of argument is whether the right at stake is even fundamental. And that determination controls whether the legislation will or will not be upheld. So what rights are fundamental? Well, now the obvious answer is the rights enumerated in the Bill of Rights. They were so fundamental that states insisted on their enumeration in the Bill of Rights. But in addition to these enumerated rights, constitutional law has identified certain implied substantive due process rights that are protected by the strict scrutiny of the judicial system. The determination of what these implied substantive rights are is probably the most controversial area of the constitutional law. And remember, the 9th Amendment says that the Bill of Rights was not an exhaustive list of all rights held by we the people. But it doesn't say what those other rights are or what they ought to be. So constitutional case law has provided the definition of fundamental rights. And it began with the Supreme Court decision of Griswold versus Connecticut. In Griswold versus Connecticut, the U.S. Supreme Court considered a Connecticut statute that made it illegal for a doctor to advise a patient on the use of birth control. This was 1965, and birth control pills were just entering the market of women's health care. Connecticut's legislature made their use illegal. A doctor was arrested and fined for advising a married couple, mind you, for advising a married couple about the use of birth control pills. So the doctor and I can't remember, there was another party, appealed the conviction all the way up to the U.S. Supreme Court, and they argued that the law infringed upon a fundamental right, the right to marital privacy, or more specifically, the right to choose whether and when to conceive a child. The U.S. Supreme Court acknowledged that there was no enumerated right of marital privacy, but then held that there were certain, and I'm quoting, penumbra, P-E-N-U-M-B-R-A, penumbra, or emanations from the rights that were enumerated, such as the Fourth Amendment's right to be free from unreasonable search and seizure. So the court held that the Constitution affords people certain substantive implied due process rights, so rights that are due to citizens of this country simply because they are citizens. These are substantive rights, a right to do something that will be protected even though they're not specifically enumerated in the Bill of Rights. That case, Griswold versus Connecticut, set a precedent for several other related issues of privacy: contraception, conception, and marriage. It established the precedent for what is known as substantive due process, the idea that there are certain rights, substantive, not just procedural, rights that citizens are simply due or entitled to have as a matter of human liberty. Substantive due process is supposed to be limited by evaluating the right through the lens of history and tradition. And the question becomes whether our society has traditionally protected the right over the course of history. In the Griswold case, for example, the court looked at the fact that through the history of our country, what our tradition has always been is that the marital institution is a private institution. And therefore, the court found it the right to marital privacy to be fundamental, and it invalidated the Connecticut statute that prohibited advising married couples about the use of contraception. And now it is well established that U.S. citizens of a free nation, have a right to privacy in matters of marriage and family. So to recap, we've been talking about the power of judicial review, which is the power of the U.S. Supreme Court to evaluate whether an act of a co-equal branch of government, Congress or the President, is constitutional. The court exercises the power of judicial review by applying certain tests or standards of review. Those tests are strict scrutiny, intermediate scrutiny, and rational basis. The choice of which test is applied depends upon whether the legislation disproportionately affects a suspect class or whether it infringes upon an individual's exercise of a fundamental right. I've included here a picture of Mr. and Mrs. Loving. They are the people who commenced the landmark case of Loving versus Virginia, in which the right to marry was infringed by Virginia's anti-miscegenation law, or law that banned interracial marriage. Loving versus Virginia is a good case study because in it, the U.S. Supreme Court was dealing with both an equal protection issue and a fundamental rights issue. Equal protection was at stake because the law involved a racial classification, that a member of the white race could not marry a member of the black race. And it also involved a fundamental right, the right to choose who you marry. One of your assignments for this chapter is to read that case and write a summary of it using the FIRAC structure, F-I-R-A-C structure. So facts, issue, rule, analysis, and conclusion. You'll see more details about that assignment in the agenda. That concludes the recorded lecture for Chapter 3.